within our second panel, titled Life, Religious Liberty and Family, we are going to listen to other distinguished scholars. Firstly, we are going to listen to the presentation of Thana de Campos, and she is the assistant professor at the Pontificia Universidad Catolica de Chile, and she's going to present about the flourishing of mothers. Afterwards, we are going to hear from Eric Claeys, who is a professor of law at the Antonin Scalia Law School at George Mason University, and he's going to talk about natural law, natural rights, and contemporary property policy. And within this panel, our moderator is Stephanie Barclay, who is a professor of law at Georgetown Law School, and she's also a faculty co-director of the Georgetown Center for the Constitution. And with this, I would like to give the floor to Thana de Campos in order to hold her speech. Thank you very much.
Thank you, Johanna, Chris, and Ferenc for the invitation to speak. It's wonderful to be with friends, old and new. So I was asked to offer some words on how natural law could help us make sense of this persistent, obnoxious, big problem that men need to solve, called women. And it might be impossible to find reasons that can justify the hormonal behavior of these human beings called to motherhood, but I'll try my best. So Johanna and I are starting a research project titled Flourishing Mothers Towards a Philosophy of Motherhood, and we thought it would be good to get some initial feedback from this group. Law and public policy have most recently been trying to solve the problem of motherhood. So there have been debates on the topic of paid and extended maternity leave, subsidies for parents, childcare reform, the population decline, childless families, questions on abortion, adoption, and all of these are directly related to the topic of motherhood. And yet, current laws and policies lack a comprehensive and a coherent approach to motherhood that guides governments on how to properly support mothers in particular, and caretakers in general. So in lacking a coherent approach to motherhood, states fail to address questions of caregiving in a satisfactory manner. And yes, these various questions are addressed, but they are addressed in a fragmented, often contradictory way, as I will explain. There's no deeper understanding of what motherhood is in a philosophical sense, what is the distinct value of motherhood, and how we ought to protect motherhood so that women can flourish. The overarching argument that Johanna and I want to present through this project is that natural law, and more specifically a natural law approach to an ethics of love and care, can fill this knowledge gap. And by love here, I mean the virtue and the practical reason that serves as a directive for both individual and institutional deliberations. So love grounds a universal yet personal duty to care for those entrusted to us. So love is universal yet also relational and deeply personal. I love the person, the unique person in front of me, by giving her my presence, my attentive gaze, as Iris Murdoch would put it. So the Flourishing Mothers Project is driven by this recognition that human flourishing requires institutions to be centered on relationships of love and dependence, and a Thomistic and personalist understanding of love as willing the good of the other in the uniqueness of the other in front of me, who I'm called to love, plays an important role in designing institutions conducive to the flourishing of mothers. So law and civic institutions should, we think, have a special concern for the flourishing of mothers, who are at the heart of civilization. And in order to present our natural law approach to motherhood, I'll first briefly introduce one fragmented account that we are trying to tackle. They're trying to tackle the problem of motherhood to then introduce our natural law alternative, which, by the way, doesn't look at motherhood as a problem, but as the solution itself, the solution for a flourishing community. So a few words on the problem of motherhood and this existing fragmented account that we are looking at. There is a growing awareness that there is a social co-responsibility to care for the most vulnerable, and thanks to feminist care ethicists, there is also recently an incipient awareness of our shared duties to love and care for mothers, the invisible caregivers of all. Very recently, in 2022, the Organization of American States, together with the EU, issued the Inter-American Model Law on Care. This was mainly in response to what these international organizations identified as the global caregiving emergency exacerbated by the COVID pandemic. This global caregiving emergency has produced, their evidence shows, some negative impacts on women, especially on their full participation in the labor market and therefore on their economic autonomy and their empowerment. So what the model law on care wants to do is to correct this gender imbalance that exists in caregiving duty so that women are not excessively burdened by them. How does the model law on care want to correct this imbalance? They want to establish care as a right, a fundamental human right, more specifically, correlated to a shared responsibility for care. And this is how the model law on care defines care as a human right, as I quote. Everyone has needed and will need caregiving at some point in their life. It is the basis of life and thus the right of every human being to receive care. In that sense, it is the responsibility of all sectors of society and thus the importance of shared social responsibility. End of quote. So in principle, I believe this right could be reasonably justifiable for a natural lawyer because this new human right is arguably grounded on correlated duties. So in principle, this human right to care wouldn't be yet another human right that is just amply proclaimed on paper because there seems to be a heavy emphasis on the need to recognize caregiving first and foremost as a shared responsibility. And our duty to others are, I think, at the very center of the natural law tradition. The problem is that while there is a heavy emphasis on the idea of co-responsibility for care, when the model law on care elaborates on the purpose of this human right to care, the model law doesn't justify this new right in relation to shared duties. Instead, the model law grounds this new human right primarily on the economic advantages of having women's active and equal participation in the labor market. So the primary reason for this human right is to make women independent rather than fostering social structures that allow us to care for one another, acknowledging our interdependence. This is the first contradiction that I found in the model law on care. At first, I thought the model law on care wanted to establish a human right to care because, especially after COVID, there is a growing awareness on the need to normalize the fact that we are all interdependent and that we want to create a society where people can care for one another. But after reading the model law on care more closely and the justification it gives for this new human right, I was surprised to see that the model law is simply reinforcing the conventional rhetoric of independence and unconstrained individual autonomy. And by justifying the human right to care in this individualistic way, what the model law on care does is actually to reinforce the view of moral obligations as chosen and right holders as unencumbered, autonomous, productive, able-bodied male citizens. This is the anthropological view that shapes our individualistic culture and institutions. And within this anthropological view, the unencumbered, able-bodied male is the norm and the standard for what a good, flourishing life should look like. And therefore, the female body and its natural reproductive powers to gestate male life are the deviation, that is the problem that needs to be corrected. So it's kind of funny that the model law on care, in its desire to be pro-women and pro-caregivers, actually reinforces this kind of misogynist anthropological view of rights that reduce motherhood and caregiving to chosen obligations and a quasi-contractual relationship between caregiver and child, when instead the model law should be upholding an anthropological view of rights that is centered on our duties to others. And this is where I think the natural law perspective comes in neatly. So the natural law account offers an alternative to this autonomy account of human rights because it's centered on our duty to love and care for others, for their good and for the common good. So the natural law approach to motherhood that Johanna and I are developing does at least two things here. First, it corrects the internal contradiction of the model law on care by showing why the proposed human rights to care cannot be grounded in female autonomy and economic independence. And second, it corrects the internal contradiction by providing a deeper understanding of the necessary correlation between rights and duties and the primacy of duties over rights. The model law on care fosters debates on some specific legislations, especially across Latin American countries, including laws on maternity, paternity, and parental leaves, leave for care of the elderly and other dependent adults, like people with disabilities, as well as breastfeeding policies in the workplace and child care services. So, for example, the legislators in Chile are currently reforming their daycare laws. And I believe in the US there's also some debate around child care reform currently. What the Boric administration in Chile is trying to do is to push a law that will provide universal access to daycare. So what is the legislative intent here? They want the law because they believe it's key to bring moms back as soon as possible to the workforce and the market. This, they claim, is crucial for women's economic independence and empowerment. So the Chilean legislators here are using the language and the logic of the model law on care, and they are also replicating the internal contradiction of the model law that I just identified. If the Chilean debate on daycare were grounded instead in the natural law approach, perhaps legislators would not be trying to push for a universal access to daycare to separate mother, father, and baby as soon as possible by putting the parent, especially the mother, back in the workplace as soon as possible. Rather, the natural law approach would perhaps make the legislators favor a more flexible approach that would give families the authority and freedom to choose the child care arrangement that works best for them. So instead of a universal access to daycare, perhaps the Chilean legislators would be advocating for subsidies directly given to each family, so they would decide how to best allocate that money for the caregiver, for the care of their newborn. Just to be clear, I'm not against daycare. My employer, the Catholic University of Chile, offers actually a premier daycare, totally free, where my child is fed Mediterranean diet. So my daughter has actually a better diet than I do, and this is wonderful. And the daycare works for me, for my husband, and for my 2-year-old Isabel. But perhaps it may not work with my newborn Samuel in a few months when I have to. When my mat leave ends and I have to be back in campus. So I believe direct subsidies for parents that empowers them to decide which daycare arrangement is best for them is a better way to perhaps spend government money than to build daycare facilities and hire caregivers all over the country, which may end up not being beneficial to all children. This idea is this direct financial aid to parents has been advocated by social conservatives and many in the pro-life movement in Canada for many years, for example. And a natural law approach would here I think, invoke the wisdom of the principle of subsidiarity to challenge one-size-fits-all policies such as this that do not really serve all mothers, all women, and all families well. So I'll stop here, but these are some of my own reflections on how a natural law approach could contribute to the current debates on care and could also provide perhaps a common ground for liberals and conservatives to agree on certain family policies that might address also the problem of childless family, which I think it's a problem here in Europe. Thank you.
I want to begin by thanking Kalman and Johanna for inviting me. It's an honor to come here, and it's an honor to be presenting with a lot of other scholars whose work I know and admire and have learned from. And it's a great honor also to be presenting at a Scrutin Cafe. I read about these with envy and admiration because I was a college student, not learning nearly as much as people in cafes in Czechoslovakia and Hungary were learning in the 80s. So if I can give back now, I'm grateful to do so. I guess also I want to offer a couple of contrasts with Thana's remarks. So one contrast is that she said her project is at the very gestational early stage. Mine is done. The remarks I'm going to give you are about a book. The production editors let me know the book's coming out in a couple of months. So the ship has sailed. But still, part of being an academic is to promote one's work. So thank you for your patience in advance while I tout the book. But also, I think that Thana's topic and mine they differ, but in a way that should help the group in our discussions. Thana's topic about motherhood, I think, focuses primarily on the dimensions of natural law that focus on responsibility. There are rights that come out of those responsibilities, but I think the responsibilities are primary when you're talking about the family and the responsibilities of parents. I'm going to be talking about property and property as a natural right, but the natural right can be ordered with correlative responsibilities. And so I think for people here, one of the things to ask is, why does the natural law lend itself to talking about duties and responsibilities in some contexts and rights in others? And in my remarks here, I hope to make 2 points. I want to accomplish 2 goals. One is I want to introduce property understood as a natural right, consistent with natural law. And when property is justified as a natural right consistent with natural law, it consists of a right that is about something that is not a person or an attribute that's impossible to separate from a particular person. That right entitles people to fair opportunities to acquire and use resources that aren't people. But people need to act in ways consistent with principles of natural law, to exercise their natural rights in relation to specific resources and respectful of others' equal opportunities to exercise those same rights. And as will come out, a natural right requires people the right holders to satisfy 3 conditions: productive use, claim communication, and sufficient access. The other goal I hope to accomplish is to offer some thoughts about how natural law filters into or informs law and political discourse. I say this because many of the other talks at in this conference are going to talk about human rights and constitutional or treaty guarantees of fundamental rights. Natural law principles can inform these fundamental rights, but I think natural law more often works more in the background of positive law, and the topic of property is going to bring that background role out much more clearly than a lot of the other talks. And so I'm going to stress that natural rights supply standards in politics for judging whether laws are good or bad, and sometimes natural rights can fill in gaps in legal sources when the legal sources are not entirely clear. So now back to my first goal. Why does it matter whether property is justified consistent with principles of natural law? I have an answer. I'm a law professor, so I have 2 answers in the alternative. So the first answer is the philosophical answer. So assume that 10 people come across a resource. And again, this is a resource. It's not a person or some good that is inextricably intertwined with a particular person, like a name or a body part or a reputation. The resource could be an animal, a plant, fuel, an article that can make a tool, a business opportunity, an idea. All of my 10 hypothetical people want to use it, and they want to use it more than seems consistent with they're all using it at the same time. Can one of them claim with justification that he deserves priority higher than the other 9 for his intended uses? If he comes up with such a justification, what happens if the other 9 ignore him? Can he repel them with force? And now we get into a topic that Veronica raised in her question in the first session. So now what if the law steps in to back up the claimant's claims to use force? Could the government arrest the 9? Could it lock them up? If they resist, could it use lethal force to make sure that they obey the law? In political philosophy, the most basic question is why a government may ever use force, including lethal force, to carry out its laws and policies. Governments can use force in some circumstances. To use such force, though, on people who object to specific laws or policies, the governments need to justify the laws that they're going to back up with force. The justification must focus on the right topics. Topics about the common good, and the common good is the topics that the government oversees for the mutual benefit of all the citizens in the community. And not only must the justification be on the right topics about the common good, it must be a convincing justification. Natural law refers to a way of thinking about practical human action. And in the book, I assume that natural law means what it means in the Thomistic tradition, broadly speaking. Some things and activities are objectively good for people given what we know about human nature. Natural law gives people guidance in ethics and their choices how to make their own lives flourishing lives. But natural law can also give guidance in politics about the general policies that communities of people set for members of the community to prosper as individuals in one common community. And natural law can justify laws and policies convincingly enough to warrant the use of lethal force, including with property. Now, my second answer to the question, why does natural law matter, is for bureaucrats. And I mean by bureaucrats here, we can all imagine in our mind's eye a government official, I'll call a technocrat, someone who wants to manage things without constraint from any fixed, clear laws. So we can imagine a system in which technocrats want to manage all of a community's property resources for the common welfare without constraint from any general rules. And so in a country of 100,000, a country of 1 million, a country of 10 million, could technocrats manage all resources for the common welfare by administration without general laws? And I hope I don't need to persuade you. I don't need to persuade the people from Hungary here with the tradition they know that it's impossible, it doesn't work. So if governments cannot manage resources by administration without general law, then how best to manage resources? And one answer is to delegate authority to manage those resources to small groups of people or to individuals on conditions that let other individuals manage their own resources so that everybody gets discretion to manage his or her own, respectful of others' equal opportunities to do the same. And the principles that provide the philosophical justification in my first answer end up being the same principles that a government can work with to develop rules for people to follow, because the rules that people will follow regularly to do what the technocrat wants to do are ones that are legitimate and convincing. So what are those principles? In the book, I treat 4. One of those is pretty specialized, so I'll focus on the other 3 in this talk. So here are 3 principles of natural law that give focus and structure to a natural right relating to property. First and most basic, property is for productive use. Productive use makes property rights Lockean because productive use means what it means for Locke in his second treatise, chapter 5, by labor. Labor is using a resource to the best advantage of life and convenience. By natural law, people are capable of and supposed to flourish. Unlike most other animals, people are technical. They don't have hides, they don't have claws, but they do have capacities to figure out what they need and to develop plans and artifacts to do what hides and claws do for animals who have them. And so people can take resources that aren't other people to try to carry out their projects for flourishing. And then people have active intellects, planning capacities, tendencies towards industry, and they want to use all these tendencies to make tools to carry out their plans for flourishing. Second, property rights require claim communication. Productive use is something that's valuable for every person, but in any one community, my hypothetical with 10 people competing over one resource, all of them are capable of productive use. Since all people are capable of acquiring resources for productive use, it's not enough just to start using a resource. A person respectful of his neighbors should give them fair notice that he means to take a resource and appropriate it for his own uses and warn others, find other resources for your own uses as well. That's claim communication, and claim communication adds a Grotian or a Pufendorfian element to property. Grotius and Pufendorf, when they justify property in law, they say property requires occupation or possession. And those are legal terms for a more pre-legal understanding that one must interact with a resource that gives others fair notice that the person who's using it intends to use it exclusively. So productive use and claim communication justify prima facie property rights. But prima facie property rights can be overridden. Prima facie rights are justifiable as long as the people who are excluded by use and claim communication can't find other resources of their own. The 9 can go find something else for their own resources. If there aren't enough resources to go around, you run into problems that Locke recognized with his enough and as good proviso, or that the Catholic social tradition recognizes as a community of goods, that one person takes too much from the community of goods, other people can assert their claim to the things in the community. In the book, I call that the sufficiency proviso. And the sufficiency proviso provides a justified reason for people who have been excluded from a resource to try to claw back some of that resource and use it for their own goods. In extreme situations, the sufficiency proviso justifies limiting property rights. In practice, however, typically in the right conditions, property, and particularly the institution of ownership, satisfies the sufficiency proviso indirectly. In the right conditions, private ownership encourages owners to save, improve, produce more, and if there are opportunities to work and there's a steady market, then the people who don't have some of a resource can acquire the wealth they need by work to acquire the products of the people who own things. And so a lot then of the detail of property law is figuring out in what conditions that justification makes sense and works in practice, and when it breaks down, and then there need to be corrections or firewalls on property or limits on ownership. So natural rights spell out the conditions in which people are entitled to conventional rights and particular resources. And by implications, the conditions in which people who don't have rights in a particular resource are entitled to challenge those conventional rights. So in this understanding, natural rights set measures for conventional laws about property. And that concept of a measure stands in contrast to a few other ways people might think about a natural right. Among libertarians, there's a view that a natural right is a sphere of autonomy that can never be interfered with. And on some topics, I'm thinking in particular of a right of conscience in relation to worship and religion, maybe I think that understanding of a right makes sense. But many other rights don't work that way, and in property, they certainly don't. In the natural law tradition, on most topics, natural law supplies legislators with broad standards. Thomas Aquinas talks about the phenomenon of determinatio. There's a broad standard, and a law sets a convention that makes that standard concrete in practice in a way that people could coordinate their affairs around more reliably than the broad standard could. So natural law doesn't mandate any particular entitlement. It sets a standard for evaluating the conventional entitlements that legislators and judges develop. So then, the other contrast I want to draw is the way that Jeremy Bentham thinks about property. So Jeremy Bentham, for property scholars, is famous for lambasting the idea that property could be the subject of a natural right. In a theory of legislation, he said, property and laws are born together and must die together. Before the laws, there was no property. Take away the laws, all property ceases. There's a grain of truth in his argument, and there's a ludicrous conclusion that follows from it. So to see the grain of truth in the ludicrousness, try this sentence. Before speed limits, there were neither rights to travel nor rights to personal safety on highways. Take away all the speed limits, all rights to travel and personal safety cease. So the truth is that speed limits are artifices and conventions. It's ludicrous to say that speed limits are entirely conventions, because they're conventions that have a point, and the point is to coordinate the rights of some people to travel with the rights of others to be safe from 3,000-pound motor vehicles. And there again, determinatio is describing the move that's made from attempt in principle to reconcile two rights to a specific law that provides a more determinate measure and convention for people to follow. Now, this is a conference on natural law and real-life problems, so let me sketch a few real-life implications. And as I do so, I hope that what will come out is that I think that natural rights, when applied in property, do most of their valuable work in setting a standard for property laws rather than providing a direct source in law. So natural law supplies the clearest guidance on basic topics. And so I think basic principles of natural law have a lot to suggest about property policy in the developing world. So in the developing world, many resources are held by governments, so public lands, public forests, nationalized petrochemical reserves. So a question that can be asked is, when the public owns broad swaths of a resource, does that accord with the idea or the imperative that property is for productive use? And that's a question you could ask about a lot of resources in a lot of the world. Now, there are places in a natural rights system to have public commonses, but the question that ought to be asked about any increment of a resource is this. What uses are genuine public uses by the whole community? What uses are ones that can only be facilitated if a resource is marked off clearly from others and the person who has marked it off can put it to private uses and coordinate with others doing so? And another challenge in the developing world is one that's been studied by Hernando de Soto in his book, The Mystery of Capital. So in The Mystery of Capital, de Soto observes that in a lot of the developing world, and especially in urban centers in the developing world, governments issue formal titles and people in urban centers ignore these titles. So there's a lot of customary possession and use of things by people who are not the titular owners of those things. And in natural law terms, that insight that there's a mismatch between titles and possession in real life, that's a problem in claim communication. The government set up conventions about claim communication, but the titling systems are hard to run through. Bureaucrats make them hard to work with. They're expensive and they're slow, and so people ignore them. And so another major challenge in the developing world is to reform titling systems so that they are easier to use, easier for people to get titles, and people in communities are more likely to follow the conventional titles. In developed countries, the challenges tend to be different. Such countries have rich legal systems with regulation, and the question is often whether the regulations order different people's uses in ways that seem to facilitate equal opportunities of use. Property needs regulation to make sure that legal rights protect citizens' equal rights to acquire resources and use them. But regulations need to be clear, even-handed, and proportionate to the problems they address. So problems can arise with land use policy, where land use policies are meant to address pollution problems, but then they might impose straitjackets that make it harder for people who don't live in a community to acquire housing. And so that's something where the laws are tolerably clear, but the laws can be judged by whether they're giving people equal opportunities to acquire and inhabit housing. And there are trade-offs and there are difficult choices to be made, because you want a system that gives people freedom from excessive pollution, but you also want these laws not to be used as a guide to exclude outsiders from coming into the community. And now in the cases like those, it could be the case that a lawyer might see some natural law lurking in the background of the regulations or the enabling statutes that authorize those regulations. But more often, the law will be reasonably clear, and the question is whether the law and the regulations that follow from it seem just or seem needing reform. Now, there are other situations where natural law principles might filter more directly into legal reasoning. And so one example that comes to mind where I live in the United States has to do with drones. So in the 1920s, 1930s, and 1940s, when commercial air travel was becoming common, lawyers in a lot of countries needed to ask themselves whether an airplane trespassed over private land when it flew over that private land. And the answer was no, but that required a new round of determination about property and land, its relation to property in the air. And we may be faced with another version of that determination now with robotic drones that are run by Amazon and other companies to provide deliveries. And in a case like that, you can consult the policies fundamental to property law. And in the airplane cases, the best reasoned opinions that I know of went back to principles about use and possession and asked whether it would enhance use and possession to say that airplanes trespassed or to say that the air above a certain height was public commons. And those same questions about use and possession, I think, can provide the starting point for asking about drones. So those are the main points I want to offer. And the main points are that property can be understood as a right that coordinates behavior around use and claim communication, subject to a sufficiency limitation. And then that provides a standard to measure laws by. And in a couple of cases where the law allows it, you can consult those same principles to then adjust law that might seem to be adapted badly. And with that, I thank you again for your time. I look forward to your questions.
Thana and Eric for those excellent presentations. And with that, we'll open it up to the audience for your questions. Yes, over here.
Yeah, I want to ask about subsidiarity and trust, because I think this is a way to tie both of the papers together. And it also relates with commons, because some people view education as a commons, and even childcare as a commons for the whole community. So the question is on two parts. First is that there are a lot of people who view when the government becomes more involved with childcare, when they get their teeth into it, they can corrupt it. There's a lot of instances of local communities trying to educate their children, and then the state coming in from outside and saying, no, you have to do it this way. And this seems very against flexibility, but it seems that any time government even provides funds to childcare, it in some way gets its connection and gets some control over that. And in America, people are very concerned about this with the private schools now taking government voucher money, that the government will become more involved. On the property side, when we're talking about common pool resources and the governance of them, there's been many cases where we have a common pool resource that's working pretty well. Local fishermen, for instance, are rotating between spots, and it's functioning well, or cattle grazing and stuff. And then a property regime comes in and sort of messes up the whole thing. So my question is, what is the natural law connection between, an alternative between property and the state for dealing with these common resources?
Thank you. Thank you for this question. I think subsidiarity holds these two things in tension, right? You don't want the state encroaching on your family and telling you what to do and how to educate your children. But at the same time, I think we are, across the world, we are seeing how necessary some policies from the state, a system of support, is also necessary for mothers to flourish. So I think it has to be held in tension, and you have to analyze what works for the States or what works for Chile might be different because the cultures are very different. But at the same time, I see the debate in the U.S. and I think even social conservatives are willing to perhaps understand that some sort of social benefits or some sort of structure there is necessary. Also to make it possible to have some family policies, and which is for the pro-life cause as well. So I think that's a good way forward. But the right amount of and how it's going to look like, I think it's going to be very particular to every country and every culture.
I'm not sure this is responsive to Nick, but it's a good first try. I think natural law and natural rights set a framework for looking at different property regimes in customs and in law. And on the topic of common pools, it said, like, the principles set a framework for evaluating them. It sets it gives you a set of insights and a set of questions. And so the insights would be, if you have a common pool resource and then you have a regime of cattle grazers or fishers, they're setting up what in the natural law tradition would be called a system of usufructs. And so there are uses, and the uses are conducted in a way that are coordinated, and the coordination, the conventions that the fishermen and the cattle grazers work out, those are the evidence of claim communication. And so things are working pretty well. But then the question you'd want to ask is, are those cattlemen or those fishermen the only people who might deserve opportunities to use the resource? And so the question to ask about the cattle grazing is, might there be sheep owners who want to graze too? Might there be people who want to build houses there or use houses commercially, and the cattlemen saying, like in all the American Westerns, go away, we're going to shoot you, and get bad guys to shoot you? And that's a sufficiency problem. And a political community then has to look at all of the people who have reasonable claims on that land or the fish and waters, and ask whether the cattlemen and the fishermen are denying others sufficient access to that resource. And that's the basic principles. You then have to ask questions of fact about whether there are other resources that could provide substitutes, and then the principles then inform and really motivate the political debates about those resources.
Mariana had her hand up.
Thank you both. This is a question for Thana. So I really liked the approach, and I like the focus on relationship. Maternity is always thought of as an individual thing, and as far as I know, you can't think maternity without paternity, so I think that's an advantage. But I have two questions in relation to the more relational approach. First, I wonder whether there is a difference depending on the perspective from which you understand maternity and flourishing of women and community. So in every relationship, you have sacrifices and different responsibilities and levels of responsibility. So if you think of maternity from the lens of the children or of the women and professional development and all this stuff, or the father, I wonder if there is a distinction depending on the point of view from where you're assessing the problem, and if that brings out different challenges and different answers to the problems. That is one question. And the second one is, if we are understanding or looking at the problem from the perspective of women, I wonder if you have something else to say, just out of curiosity, about the relationship between maternity as an element of flourishing for women in particular, and how is maternity contributing to human flourishing in maternity, for women, considering that there are women that cannot be mothers or that chooses other vocations, so that, that connection, I think it's very important for the argument you are proposing. Thanks.
Thank you, Mariana. Yeah, so I think your first question, I would not see a necessary contradiction or a conflict among the different perspectives, the perspective of the mother, the perspective of the child or the children, and the father. I think if we are looking at the common good of the family and the common good of the whole community, it has to be a way in which they are all flourishing and you're finding the good for all of them. I think that's the idea of the common good as I can understand it. So that's why I think the natural law approach could give us a more integrated way to think about all these different perspectives in a coherent manner. And that's also, from the perspective of the mother, I think there's a lot of talk about how to balance career and family and all that. And I don't like the term balance. I think my work helps me to be a better mother, to be a better wife. So I try to think in terms of an integration. I think my different hats will help me to be myself and to flourish so that my family can flourish too. So I think that's how I see it as an integrated approach, not only for the mother in their different in their different hats, but also the mother, the father, and the children. Your second question, I think that's an important one too, because we are talking about motherhood, and I think more specifically we're talking to those mothers, those biological mothers, or perhaps those adoptive mothers who have a very intense and specific call to care for the children. But I think all mothers, all women are they have the identity of maternity and they have the identity of motherhood, whether it's a spiritual maternity, whether it's social maternity. I became a biological mother very later in life, and I was, I think, a social mother to my students and to people who were entrusted to my care in one way or another. So I think that's a definition that we have to perhaps clarify, but I think we will be talking in this project more about the biological aspect of motherhood, or biological mothers or adoptive mothers, but I wouldn't necessarily restrict the definition of motherhood to that specific population, because I think it concerns all women and how we care for one another, and all men, because we are all called to love and to serve. So I think we are all called to be fathers and mothers in different ways.
Connor, you had your hand up.
Thank you very much to all. So this question's for Eric. I always found Aquinas' discussion of what level of property constitutes sufficiency and what is superfluous to be quite indeterminate. He talks about your right to keep property extends so far as it's needed to maintain you and your dependents in a form of life you've reasonably adopted, but the devil's in the detail of what is reasonable. And I wonder if your book sketches out what that looks like. My own thinking, and I base this on Finniss's account and reading Aquinas, would be it would have to be a level of sufficiency that didn't just respond to the animate part of our nature, keep us alive, bare necessity, or even the animal, which is allowing us to feed our dependents, but which satisfies in response to the rational nature, allowing us to, a form of material sufficiency allows us to contemplate God and the higher things and participate in the life of the polis. But I was wondering what you thought about what level of sufficiency, when sufficiency bleeds into superfluity.
I need to congratulate Connor. He hasn't read the book, but he's found one of the loose threads and he's pulling on it. I don't dwell on this too long. To a great extent, I just follow some insights that John Simmons offers in his book, Lockean Theory of Rights, when he's talking about the enough and as good provisor for Locke. The basic insight or the argument that Simmons makes goes something like this. First, it's not a fatal flaw that the idea of sufficiency or enough as good is indeterminate. It is indeterminate, but things can only be as determinate as the subject matter allows. See Aristotle here. But then in context, sufficiency or enough and is good, it requires, I think there are two competing thoughts. One is the thought that you point towards, that people, what should be sufficient is sufficient for people not only to survive, but also to thrive. But second, and slightly in the opposite direction, people can only thrive as much as they all can given the resources that they have. So the more finite the pool of resources, then the less there is for anybody to keep exclusively, and probably the less opportunity there will be for people all to thrive, and you have to focus more on surviving.
Okay, we have just about 5 minutes left, and I saw 2 comments from Laura and Veronica, so why don't we collect both of your comments, and then we'll give our excellent presenters a chance to respond, and any final words.
Thank you. I think this is a general conceptual question for you both, and then a specific one for Eric. I'll try and be quick in the way I explain it. So the conceptual question is about rights and responsibilities, which Eric mentioned at the start of his talk. And I just wondered, Thana, because you mentioned about this attempt to frame an ethic of care within a rights-based model and how that created challenges because you were thinking more about perhaps responsibilities, relational responsibilities, and yet perhaps there is still an important role for rights properly understood within your project. And equally in Eric's project, the focus is very much on rights, but then responsibilities come in, particularly with the provisos and so on. So it was more if you had any kind of general reflections on that contrast between rights and responsibilities. And then, Eric, I have to ask you this question, but we might have to talk more about it over lunch. Have you thought about the application of your project to intellectual property rights?
And then, Veronica, if you want to ask your question.
Yes, so, hello? Yeah, so Eric, I'm going to put on my hat of the Kantian view, because I want to understand where is the notion of control in your view? Because the advantage of the kind of a Ripstein, Chris Essett's view on property, as you know, is that actually I can have the means to develop my autonomy, and that therefore gives me control. So I want to understand in your proposal where control is, which is one of the most appealing things of why we have property law. And the question for Thana, what makes it specific about women's solution for the bonding of relationships, right? That family or marriage cannot do. So, for example, the rights of man as a vulnerable as well, as dependent on women, as flourishing within family, as flourishing with children. So the emphasis on women, why no family marriage, basically? Mm-hmm.
Thank you to Laura, thank you to Veronica. All of those are wonderful questions. So in the book, I do think long about the conceptual relation between rights and responsibilities. And I think in a natural law framework, the way to think about it is, in talking about property, what's good about property is that productive, purposive activity on resources is good. And that goodness justifies rights, and it justifies in the same move correlative responsibilities. So the good's primary and the rights and the duties both follow from the good. And now for intellectual property, I have written what I think are beachhead articles signaling this view, but I haven't worked it out. The basic idea, so the discovery of a new idea that is useful for human life, that's productive use. It has to be kept secret to be claim communicated in practice. And then patents and copyrights provide legal conventional claims that are more reliable than secrecy in common practice. But then there are complications because the patent or the copyright restricts the rights of others to invent the same ideas, and then that's where copyright takes off. I'll give you a site later on this. And then to Veronica, the notion of control, when I talked about ownership, that's where control comes in. In the natural law account, use is primary. And the most simple property rights is in morality, property rights are usufructs. Usufructs can justify absolute ownership and the rights of use and abuse and control on expectation that the person who has this control produces and uses the resource and trust for others, and the surplus from that person's ownership goes to others. So control is justified by how well the controller uses what is owned, or all the people who have control. If enough of them produce from what they have and then alienate what their products to others, the control is justified by the use for others.
Yeah, thank you, Laura and Veronica. I think, Laura, I would say, I think the way I think about justice, or the way natural law thinks about justice, is always in this correlation between duties and rights. And duties actually come first, if I understand correctly. So if there is a right, there is a human right to care, or any other right, is because there is first a duty. And I think that helps us think and reshape perhaps the way we think about specific rights, including maternal health care, for example. If you think about duties first, how would we reconceptualize maternal health care, or even the talk about reproductive justice? How would that look like if we have duties first and not my autonomy to do whatever I want to do and however I want to choose to do with my maternal body? And for Veronica, yes, I think that's one of the questions that we want to clarify through this project, to look at women in their specific calling to love as mothers, all kinds of mothers, as Mariana kind of try to push me to say. I think there is a distinctiveness of motherhood in complementarity, in an integrated complementarity, like Sister Prudence Allen would define it, in the complementarity with the father, in the complementarity within the context of the family. But I think the challenge will be to voice and evaluate what is the specific way in which the mother loves, the receptive kind of love that she gives then to the family and to the father. I think that will be part of the challenge that we'll be tackling.
Please join me in thanking our excellent presenters, then we'll break for lunch.